Morning. This is the Rhode Island Ethics Commission. It's the 9th meeting of 2026. We have a quorum present. And the first item on the agenda is a motion to approve the minutes of the open session held on June 2nd, 2026. Is there a motion? So moved. Motion by Commissioner Callahan. You heard about this before. Callahan, second by
I'll second.
Commissioner Peterson. Roll call vote, Commissioner Susie.
Aye.
Commissioner Peterson.
Aye.
Commissioner Browner.
Aye.
Commissioner Callahan.
Aye.
Commissioner Stephanie.
Aye.
Richie. Aye. Commissioner Strauss.
Aye.
I'd like to say Commissioner Rabideau, but I can't. And the chair votes aye. The next item on the agenda is the director's report.
Good morning.
Morning.
Looks like we have a pretty light agenda today with, meeting should be over soon. Going through the director's report very quickly. Currently, we have the one complaint pending. That's the K. Joseph Chikarchi complaint, which is under investigation. And as you know, today you will be hearing a motion to dismiss filed by the respondent. We have just 4 advisory opinions pending right now, and 3 of them are on the agenda for today. But we're working with potential petitioners behind the scenes as we always do. So I anticipate that every meeting you're still going to have a fair worth advisory opinions on the agenda. Just a few APRA requests since the last meeting. I think about 8 as of the end of yesterday anyway. 7 of those we completed within 1 business day. 1 is still pending, but we're working with the requester who understands, clarifies his wishes, and that will still be done within 10 business days. Most of those, 6 of them, had to do with complaint-related materials relative to today. 1 related to advisory opinions and 1 related to financial disclosure statements. Just a brief update on financial disclosure. Today's not only a commission meeting day, it's also the deadline for the 60-day extensions to file your 2025 financial disclosures. So we're expecting those who requested those 60-day extensions to get those filings in probably by midnight tonight, and you'll see them in the batches tomorrow morning. We only have about 70 non-filers currently, which is a nice small number that we're still working on. Again, kudos to the investigative staff who's working every day to get those in. We're exactly on track. And just something to keep in mind is we're in the middle of the candidate declarations period, as you're probably seeing on your Twitter feeds and other places. So that was yesterday, today, and tomorrow. Everyone is declaring their candidacies. And for most of those people, all the incumbents and people who have already filed notices of organization for Board of Elections or Secretary of State, they'll have already filed their 25 statements. But a small number of people who haven't done either of those things, new candidates who are just now organizing, those are the people who the 30-day window will open starting tomorrow. They'll file their financial disclosure statements in the next 30 days. We'll get a list over of all the candidates. We'll go through it, find the new people that we need to contact, and we'll send every single one of them filing instructions, online filing instructions, a copy of the paper form, and help them assist them to get those filings done before the primary, so that the voters will have a chance to look at their disclosures if they wish to. General office administration matters. Our next meeting is July 14th. And really the only other general office matter, I just want to mention that every summer we take on an intern or a fellow from University of Rhode Island in conjunction with the John Hazen White Center for Ethics and Public Service. It's a paid internship through URI. This summer, we're lucky to have Tessa Grimes, who's here today with us, who's going to be working with us. Tessa is going into her last year at URI. She is a dual major in political science and criminology, also a Spanish minor. She speaks fluent Spanish, which is nice to have here at the Ethics Commission. So we feel really fortunate to have her and just want to welcome her. So we know about that. And that's the director's report.
Any commissioners have any questions for Mr. Graham? I do. Are you telling us that when you become a candidate, if you've already filed financial form, you don't have to go back and refile anything.
That's right.
Okay.
Everyone only files one per year and or updates it as needed.
And secondly, on the APRA requests relating to the item on today's calendar, aren't those documents already public?
Yeah, so they're public documents. The way that this has traditionally worked is whether we're talking about draft advisory opinions or motions, especially because this is a pre-probable cause motion, which doesn't necessarily absolutely have to be an open session. The commission regulations mandate that post-probable cause hearings are in open session, and but this one is an open session. So yes, they are, but the commission traditionally releases those types of meeting materials, whether it's for a motion like this or advisory opinions, the morning of the meeting when they are officially in front of the commission. So at about 8:05 or 8:10 this morning, we uploaded all of those pleadings onto our website. They're available right now under meeting materials.
Yeah, my point was only if you have them already up publicly, you don't have to provide them for an APRA request, but you're saying they weren't up publicly yet, so you provided them, correct?
Yeah, I mean, we consider it, you know, if someone asks for a document that we consider a public document, we want to comply with APRA. We can an APRA request and we count it towards those numbers, especially if we have to direct someone to our website in order to access it upon their request.
Any other questions? Thank you for that report. Next, is there a sign-in sheet? First, these are the advisory opinions, and first sign up is Richard Poole. Morning. Morning.
Good morning, everyone. Hello, the draft for this petitioner is at tab A in your binders. Welcome, Mr. Poole. The petitioner is a member of the Coventry Town Council. He seeks an advisory opinion regarding whether he is prohibited by the Code of Ethics from participating in town council discussions and decision-making relating to whether or not the town should dispose of its inventory of vacant municipal lots and buildings to private parties. The petitioner was elected to the town council following a special election in August of 2025 to fill a vacancy. He does plan to seek re-election this November. In his private capacity, Mr. Poole has held a real estate license for 7 years, is now an associate broker, and has been working as a real estate agent for Remax Revolution for the past 2 years. He is one of approximately 300 agents currently working for Remax Revolution as contractors. In his professional capacity, the petitioner occasionally lists and sells residential properties that are located in Coventry. He explains that his private work has never required him to appear before the Coventry Town Council or before any of the town's boards, commissions, or agencies over which the town council has appointing authority. The town has an inventory of about 174 vacant parcels of land and buildings, which, if sold or otherwise transferred, would put them back on the town's tax rolls and result in some revenue for the town. The petitioner would like to participate in town council discussions and voting relating to whether or not the town should undertake to sell or otherwise transfer these vacant properties. Petitioner represents that he would not personally act as a real estate agent or broker for the town, nor would he list any of the subject municipal properties in his private capacity or represent private buyers attempting to purchase them. Petitioner further represents that should the town council decide to undertake the transfer of the currently vacant properties in the town, whether through sale, auction, or otherwise, he would not take part in discussions and decision-making beyond the decision of whether to transfer these vacant properties, given the likelihood that his business associates, namely Remax Revolution and the 300 agents, would seek to participate. Petitioner emphasizes that his question to the Ethics Commission today is limited to whether the code prohibits him from participating in his public duties regarding whether to transfer the vacant lots and or buildings, not the manner in which any decision to dispose of the vacant lots or buildings would be accomplished, or any subsequent actions relating to the transfer or sale of the vacant properties. Looking to the code, Mr. Hool may not participate in any matter as part of his public duties in which he has reason to believe or expect that he or a member of his family or a business associate or a private employer will be directly financially impacted by reason of his official activity. And a public official has reason to believe or expect that a conflict of interest exists when it's reasonably foreseeable, meaning that the probability of a conflict of interest is more than conceivable, but less than certain to occur. A public official must recuse himself from participation in a matter when his business associate or a person authorized by his business associate to act on the business associate's behalf appears or presents evidence or arguments for the public official's municipal agency, the exception, of course, being during a period of public comment. Finally, a public official may not use his public office for pecuniary gain for himself, for a family member, for a business associate, for any business by which he is employed or which he represents. In order to determine whether the provisions of the Code of Ethics that I just mentioned are implicated, it must first be ascertained whether the petitioner or his business associates, again, Remax Revolution and or one of its agents, would be directly financially impacted by the official action that is under consideration here, which in this case would be the petitioner's official participation in discussions and voting relating to whether or not to dispose of the town's inventory of vacant municipal lots and buildings to private parties. If a direct financial impact is not reasonably foreseeable as a result of the petitioner's contemplated action, then the petitioner will not be required to recuse relative to that particular issue. Page 3 of the draft cites 3 previously issued advisory opinions where public officials were allowed to participate in official matters in situations where a financial impact was hypothetical and indirect in one situation, absent in another situation, and speculative and remote in a third situation. Here, the decision about whether to offer vacant land and buildings in the town through auction and or sale would not result in any direct financial impact on the petitioner or his business associates. Accordingly, based on the facts as represented, the applicable provisions of the Code of Ethics and consistent with prior advisory opinions issued, it is the opinion of staff that the petitioner is not prohibited from participating in the contemplated official activity relating to whether or not the town should dispose of this inventory. However, in the event that the town council decides to do so, Mr. Hool is advised to either recuse from participation in subsequent matters relating to this issue or to seek additional guidance from the Ethics Commission. I'm happy to answer your questions or to defer to the petitioner as you see fit.
Morning, Mr. Hool. Is that pronounced correctly, Hool?
It is, yes, thank you.
Do you have any questions, concerns, comments concerning the advisory opinions that you've received?
Nope,
Draft?
I think it's fair and reasonable, keeps me out of trouble all the way around.
We appreciate you coming in for that.
Thank you.
Anybody have any questions for either Mr. Regis or Mr. Hool? Is there a motion to issue the advisory opinion as present? That's actually to approve and issue the advisory opinion as presented by the staff. Motion by Commissioner Ritchie, second by Commissioner Browner. Roll call vote, Commissioner Susie,
Aye.
Commissioner Peterson,
Aye.
Commissioner Browner,
Aye.
Commissioner Callahan, Commissioner Centerini, Commissioner Ritchie, Commissioner Strauss. Aye. Chair votes aye. Thank you.
Thank you all for your time. It's getting dry today. Thank you so much, you as well. Enjoy the rest of the week.
The next item on the sign-in sheet is Henry Lombardi.
The draft for this petitioner is at tab B in your binders. Welcome, Mr. Lombardi.
Morning.
Petitioner works for the Rhode Island Secretary of State's office as an advance/courier. He seeks an advisory opinion regarding whether he is prohibited by the Code of Ethics from seeking election to the Middletown Town Council. Mr. Lombardi has held his current position for more than 3 years. His advance duties include visiting venues at which the Secretary of State will be attending events prior to the time of each event for purposes of assessing the security of the venue, including parking availability, and finalizing event details with the event coordinator in advance of the event. He will often accompany the Secretary of State to these events. Petitioner's courier duties include picking up and transporting documents to and from the Rhode Island State House and various municipal offices throughout the state. Mr. Lombardi's duties also include assisting with the operation of Rhode Island's Address Confidentiality Program, which provides vital services to victims of domestic abuse. The petitioner works out of the Secretary of State's West River office. The state's Board of Elections offices are also located there. He states that the administrative duties conducted by Board of Elections employees include, but are not limited to, the following: the placement of candidate names on ballots, the timely distribution of ballots to polling places, and the oversight of voting and ballots. The petitioner emphasizes that his duties as an advance/courier for the Secretary of State's office are separate and distinct from any associated with those of the Board of Elections members or its employees, with no overlap between the two. Mr. Lombardi is currently a member of the Middletown Zoning Board, having been appointed to that position by the Middletown Town Council in 2025. His current term expires in 2030. He intends to seek election to the Town Council in Middletown this November, and if elected, will of course resign from the Zoning Board. The petitioner informs that it has been suggested to him that due to his current employment with the Secretary of State's office, he is prohibited by the Code of Ethics from seeking municipal elected office because of the collaboration among the Secretary of State's office, the Board of Elections, and local cities and towns during the administration of elections. Petitioner reiterates that he does work in the same office building where the Board of Election offices are located, but his public duties are in no way connected to the administration of elections. The code prohibits a public employee from taking action in his official capacity that will directly financially impact himself, a person within his family, a business associate, or a business by which he is employed. The code also prohibits a public employee from accepting other employment that would impair his independence of judgment as to his official duties, or require or induce him to disclose confidential information acquired by him during the course of those duties. Nor may a public employee use his office or any confidential information received through holding it to obtain financial gain for himself, for a family member, for a business associate, for a private employer. Finally, the Code of Ethics prohibits a public official from representing himself or any other person or acting as an expert witness before a state agency by which he is employed. These prohibitions extend for a period of 1 year after the public official has officially severed his position with the subject state agency. There's no blanket prohibition against public officials or employees seeking elective office, whether at the state or municipal level. A matter-by-matter evaluation is required to determine whether substantial conflicts of interest exist with respect to the exercise by a public official or employee of his or her public duties. Page 3 of the draft cites 4 previously issued advisory opinions in which the petitioner was allowed to seek elective office under circumstances where the duties associated with their public employment had no overlap with the duties attached to the elective positions that they sought. Here, there's nothing to indicate that a conflict of interest exists between the petitioner's current state employment as an advance/courier with the Secretary of State's office and his desired candidacy for election to municipal office as a member of the Middletown Town Council. He would not be taking official action as a public employee of the Secretary of State's office that would directly financially impact his candidacy or potential election to the Town Council. Nor would the petitioner's candidacy or potential election to the Town Council impair his independence of judgment with regard to his official duties with the Secretary of State's office, or require or induce him to disclose confidential information acquired during the course of those official duties. Further, the petitioner's candidacy for membership on the Town Council will be decided by the residents of Middletown. Any related administrative duties performed by the Secretary of State or the Board of Elections associated with that election would not amount to Mr. Lombardi's representation before his own agency. Accordingly, it is the opinion of staff that the petitioner is not prohibited from seeking elective municipal office to the Middletown Town Council. Mr. Lombardi is reminded that the Code of Ethics does prohibit him from using public time or resources to support his candidacy. All campaign-related activities must be conducted on his own time without the use of any public resources. Mr. Lombardi is encouraged to seek further guidance from the Ethics Commission if there are facts not anticipated by this advisory opinion that arise and could create a conflict of interest. I'm happy to answer your questions or to defer to Mr. Lombardi as appropriate.
Mr. Lombardi, good morning again. Do you have any questions, concerns, comments regarding the draft advisory opinion that you've been given?
No.
Okay with it? Anybody have any questions of either Mr. Decius or Mr. Lombardi? Seeing none, is there a motion to approve and issue the advisory opinion as presented by the staff?
I so move.
Motion by Commissioner Centerini, is there a second? Second. Second by Commissioner Callahan, a roll call vote. Mr. Susie.
Aye.
Mr. Peterson. Mr. Browner.
Aye.
Mr. Callahan.
Aye.
Centerini.
Aye.
Mr. Ritchie.
Aye.
Strauss.
Aye.
The chair votes aye. The last advisory opinion.
Thank you, sir.
I'm sorry, thank you for coming before us, appreciate it, thanks, Commissioner. The next item is Michael Pino or Peno, I'm not sure. Pino. And stop, it's your,
Good morning,
Podium.
commissioners. This draft is in the tab C. Mr. Pino is on mute. The draft was sent via email and mail to him last Wednesday. I tried to reach him unsuccessfully yesterday, and this morning before the meeting, I haven't had contact with him.
have you had contact with him since you sent him the opinion?
I have not.
So we don't know today what his position one way or another is on the opinion?
Correct.
Does that make you comfortable that we're able to go forward?
I'm comfortable proceeding, as long as, if, with understanding that if commission disagree with staff's recommendation or have, questions for Mr. Pino, then we can postpone it.
I want to ask counsel about this one. So it's not clear to me that we can say that he's received it. We only know you sent it. He hasn't even confirmed receipt, has he?
He hasn't.
Is there any time pressures? This-
He hasn't expressed any.
I don't think there's a pending meeting or any date of any urgency, so I think it might be best to push this to the next meeting.
Is there a motion to continue this one? So motion by Commissioner Brown, second by Commissioner Susie, a roll call vote to continue this advisory opinion to the next hearing. Commissioner Susie, Commissioner Peterson, Commissioner Browner,
Aye.
Mr. Callahan,
Aye.
Mr. Centerini,
Aye.
Commissioner Ritchie,
Aye.
Commissioner Strauss.
Aye.
The chair votes aye. Thank you.
Thank you.
Thank you, Ms. Papa. The next item on the open agenda is the hearing in the matter of Henry K. Joseph Chikarchi, complaint number 2026-1. On respondents' motion to dismiss. The commission public is aware I am recused on this matter, so I will step down. Commissioner, Vice Commissioner Susie will handle this piece of this hearing today.
Jason, I'm gonna move.
Okay.
Okay, this is.
Good morning.
Good morning.
Take just a moment and go over the procedure.
Sure. Good morning, everyone. We are here on the respondent's motion to dismiss for failure to allege violation of code of ethics. Argument when you in open session. Mr. Dickinson, it's your motion. You will go first, then Mr. Lambert will go. Then Mr. Dickinson, if you have any to respond to, Mr. Graham's argument, you may. Same thing with Mr. Graham, and depending on the time, you'll both be given an opportunity to clean up if you've forgotten anything at the end. Now, this, the motion's being heard in open session, as Mr. Graham indicated earlier. Motions that are filed after probable cause are required to be heard in open session. Parties have agreed to argue this in open session. However, the commission, after the arguments conclude, may choose to deliberate in executive session. And if you do choose to do so, the only folks present for that executive session will be the commission and myself. I would not be deliberating with you, but if you have any legal questions of me, you can ask them. You can ask them now also. During the arguments, the commissioners are free to ask the attorneys whatever questions they be desired.
Madam Chair, I want to state for the record that my cousin, my second cousin, is here today. He came in late to this case. Whatever reason. Last time that he was here, I recused myself because I was surprised when I walked in to find him here. Out of abundance of caution, I sat in a room with a chair. Don't I mean that there wasn't any reason to be cute, so today I'm not recused.
I'll note that.
I have a question about what the questioners were answering today on this motion. So you've already voted on the initial determination that the complaint, if true, posits a violation of the code of ethics. So now are we voting, where are we proceeding?
Okay.
So this is unusual, doesn't
So-
often happen in this
Correct.
order. So I
So-
just want clarification about
So the
what
respondent
the
has.
question we're answering.
Respondent has filed a motion to dismiss, alleging that there can be no violation of the code because the regulations and the statutes combined do not prohibit him from immediately applying for a position on the Supreme Court. Okay, so if you agree with, at the conclusion of the hearing, if you agree with the respondent's argument that he is not prohibited from immediately applying, you should vote to grant the motion.
Okay.
Did I state that correctly, Mr. Dickinson?
I think so.
Mr. Graham, did I state that correctly? Yes.
Any questions before we begin? Okay,
Good morning, and thank you for the opportunity to appear. Thomas Dickinson on behalf of the respondent, K. Joseph Shikarji. I'm here with Albert Medici, who is also participating as representing Mr. Shikarji. The issue here is a constitutional one. The question is, what is the role of the Ethics Commission and the Ethics Code as opposed to the Constitution, or as compared with the Constitution? And the answer to that question is clear, and it's clear from the 1999 advisory opinion of the Justices of the Rhode Island Supreme Court, which I believe both of us have cited, and which I happen to have participated in as counsel for the Attorney General. And I think it's important to keep in mind that that decision or that opinion comes after the 1994 revisions to judicial selection and after the 1992 and 1993 advisory opinions that the prosecution has cited. So this has to be viewed in light of the current situation, not the situation that existed in 1992 or 1993, and not even exactly the situation that existed in 1999. Because in 2004, there were further amendments, which we'll get to. The 1994 amendments to the Constitution appear in Article 10. Well, they appear throughout Article 10, but specifically Article 10, Section 4. And Article 10, Section 4, approved by the voters overwhelmingly in 1994, again, after the 1993 opinion. The voters approved this in 1994, which established a role, a constitutional role, for the first time for the governor, established the requirement of a judicial nominating commission, an impartial judicial nominating commission, which is specifically established in the Constitution, much as the Ethics Commission is provided for in the Constitution, but 8 years later. So it's a new development after the 1986 Constitution. And also a two-house advise and consent procedure, which is unusual, I think. But as I believe anyone would recognize, prior to the 1994 Judicial Selection Amendment, justices of the Supreme Court were appointed in grand committee. So both houses of the General Assembly had a role in electing Supreme Court judges prior to the 1994 amendments. But after the 1994 amendments, we have very clear constitutional roles for the JNC, the Judicial Nominating Commission, the governor, and then the two houses of the General Assembly. It's also important to note that even after the 1994 amendments, in 2004, the voters approved the so-called separation of powers amendments. And those amendments, again, changed the landscape. How did they change the landscape? They changed the landscape because the power of the governor was greatly increased by the inclusion of specific appointment powers, or I should say general appointment powers for the governor, which did not exist prior to 2004. And in fact, in the 1993 advisory opinion, which I've mentioned before, which I think has been superseded by a number of things, the court specifically stated, and this is in our memo, the court specifically stated that the governor had no general appointment authority, and that's true. He didn't, or she didn't, in 1993. But in 1994, the governor got specific judicial power, judicial appointment power, and in 2004, the governor got even more comprehensive or extensive general appointment power. So the premise of the 1993 decision, which was this revolving door provision doesn't really implicate the governor's powers because the governor doesn't have these powers. Now the governor does have those powers. The governor has specific appointment power under the 1994 judicial amendment and more general appointment power under the 2004 amendments. Now, we placed reliance on a case called Inman versus White House, which I want to talk about for a minute or two. The Inman case, as the commission should be aware from having reviewed the materials, the Inman case was, I believe, in 2001. Secretary of State Langevin was elected to Congress, which left a vacancy in the office of the Secretary of State. Representative Inman became a candidate for that, and as the Constitution provides, and still provided then and still provides, vacancies in certain offices, including the Secretary of State, are to be filled by the General Assembly or by the Grand Committee, which is essentially a joint session of the General Assembly. Representative Inman was elected by the Grand Committee, and a complaint was filed here claiming a violation of the revolving door provision. Inman was an incumbent member of the General Assembly who sought appointment or election to the position of Secretary of State. He was elected. The case came here. Representative Inman, through counsel, filed a declaratory judgment action in the Superior Court, trying to stop the proceeding here. The case was considered by Justice Silverstein at the time, I think it's 2001. And Justice Silverstein decided in that case that because there was a specific constitutional power or constitutional procedure for replacing the Secretary of State, to wit, the Grand Committee, that the Ethics Commission could not trump that. A code of ethics, even a statute, could not trump that specific, pardon the use of that word, the specific constitutional provision for selection of a new Secretary of State. That's a case decided by a Superior Court judge. The prosecution has suggested that because it's quote unquote unpublished, maybe it shouldn't be followed, or maybe it doesn't have any value. The fact of the matter is, it's a judicial pronouncement of what the law is. And, you know, we know Superior Court decisions are never reported. They're all published online or available through Westlaw, Lexis, or one of the other online services, but they don't come out in the Atlantic Reporter like Supreme Court decisions do. That doesn't mean that it doesn't have value. It has extreme value, not only because it addresses a situation that's very similar to the one here, but in that case, the Ethics Commission was a party. And the Ethics Commission in that case, and I provided the memorandum that the Ethics Commission filed as part of the appendix to my memorandum, the Ethics Commission in that case took the position that it could not overrule the Constitution's delegation or assignment of that selection power to, in that case, the Grand Committee, noting and arguing that if there is a specific constitutional procedure for the filling of an office, neither the Code of Ethics nor any statute, because it's constitutional, neither the Code of Ethics nor any statute or this commission can override or interfere with that process. So the Ethics Commission took that position in court in that case. And that was the ultimate decision that Justice Silverstein reached, consistent with not only the Constitution, but with the Ethics Commission's arguments in the case about the Constitution. So I would submit that there's any number of reasons why the commission ought to consider itself bound, and if not bound, certainly persuaded by the decision of Justice Silverstein, whom I think we all would agree is in retirement still one of the most highly respected justices of the Superior Court. And as the Supreme Court said in the 1999 Ethics Advisory, the Ethics Commission cannot interpret the Constitution using the Code of Ethics or following ethics statutes, because that is a function specifically reserved for the judiciary. And here in Inman, we have the judiciary reaching a decision consistent with the views of the Ethics Commission, but reaching a decision on the law that says that the Constitution governs the selection process, and that the revolving door cannot, the revolving door legislation or regulations cannot impede that or cannot override that. So the other issue I just want to highlight is, as I'm sure the commission is aware, the revolving door statute contains an exemption. And the exemption, whereas it generally prohibits or generally regulates the ability of a state elected official or even state appointed officials in some cases to seek or obtain another position in state government. With regard to constitutional offices, there is a specific exemption from the revolving door for a state elected official who is seeking or being elected to a constitutional office. So the first question is the Supreme Court a constitutional office? Well, number one, I don't think the Ethics Commission can say that it isn't. I don't think anybody can say that it isn't. But I don't think there's any doubt that the Supreme Court would say that it's a constitutional office, or that the Superior Court would say that the Supreme Court is a constitutional office. Maybe you could make an argument that lower court judges are not constitutional offices. What Article 10, Section 1 said after the 1994 amendments, what it said about lower courts was that the governor would appoint Supreme Court justices and such other judges of other courts, I'm paraphrasing here, as the General Assembly might establish. So lower courts are established by the General Assembly. Maybe there's an argument those judges aren't constitutional officers. I'm not making that argument, but I can see how someone might try to draw that distinction. But there can't be any question that the Supreme Court is a constitutional office. The Constitution establishes the Supreme Court. That fact goes back to the 1843 Constitution as interpreted by the Rhode Island Supreme Court in the venerable and memorable precedent of Taylor versus Place, which I have to cite in every argument I make. I apologize for that. But that case specifically described the Supreme Court's constitutional pedigree. So the Supreme Court's a constitutional office. I don't think anyone of good faith would contest that. So is the respondent seeking appointment or election to a constitutional office? The prosecution is arguing, well, you got to look at that word election. And since there are some constitutional offices that obviously are elected, the attorney general is elected, the lieutenant governor, the governor, etc. So if somebody is the general treasurer and she wants to run for governor, she can do that. No question, no violation. And no one would suggest that there's a violation. But there's also the word seeking in that exemption. So seeking or being elected to. And what is the respondent doing? And what does the complaint allege that the respondent has done? The complaint alleges that the respondent is seeking a position on the Rhode Island Supreme Court of Associate Justice, which I think is clearly a constitutional office. And so what the complaint is alleging is something that's clearly exempt under that exemption provision in the statute.
How do you reconcile the terms elected and appointed?
I don't have to. What the words are seeking or being elected to.
So seeking to an elected position and seeking to an appointed position, how do you reconcile the differences?
I don't think they are different under the language of the Constitution. And the important point is that
You agree that you're not in Rhode Island, we don't have Supreme Court justices elected, they are appointed. So now, answer my question.
yes, Supreme Court justices are elected pursuant to Article 10, Section 4, which again, as I say, trumps any statute. But Article 10, Section 4 specifically describes a specific constitutionally approved process that includes recommendation by the JNC. Well, first application, obviously, recommendation by the JNC, nomination by the governor, advice and consent by the two separate houses, and then appointment by the governor. Because when the governor says, I want, Joseph Weisberg is not a good example. He was elected by the Grand Committee. I want Bob Flanders to be on the Supreme Court. That's not an appointment. That's a nomination. When the two houses confirm Bob Flanders to be on the Supreme Court, the governor then appoints. So it's a four-step process. And we're at the very beginning step, seeking. The statute says or, it uses the disjunctive or. It doesn't say seeking and being elected to. It says seeking or being elected to. And we've cited some cases where the court makes it very clear. You can't conflate or and in statutory interpretation. They have to be read separately. or they have to be read as having distinctive meanings. One is disjunctive, or, and the other is conjunctive, and. And so I don't think there's an anomaly here. The statute describes both seeking or being elected to. And that's, the complaint alleges seeking. And so I think under the statute, there's an exemption. I don't think we need that. Because as I said before, and as I think the law ought to be very clear, if there's a clear constitutional process for filling a position, and there is here, then you don't need to get to those exemptions.
But isn't there a clear constitutional process regarding seeking an appointment to this office as opposed to seeking to be elected to this office?
Well, this happens to be an office where the process is, as set out in Article 1, Section 4, has these steps to it. And so that's what the Constitution says. So if it were another office and say, Secretary of State or Attorney General, then we talk about, the elective process and seeking or being elected to. But here,
You can't separate the two. I mean, it's clear. You want to serve on the Supreme Court. You're not seeking an election to the Supreme Court. You're seeking an appointment to the Supreme Court. And with that, I agree that our code of ethics applies.
well, respectfully, I don't think that's consistent with Justice Silverstein's view of the process.
He never went that road. He never went that road. I read that decision. I read the decision from the Supreme Court decisions. Justice Weisberger even talked about harmonization. So I mean,
You're talking about, I think, the 1993 opinion, which I believe was written by we never know what an advisory opinion who wrote it. I believe it was written by Chief Justice Fay, based on my memory, our offices at the time, participation in it. And
I think
that's what I believe in, knowing how these things work behind that wall or curtain. That's my suspicion. I think very clearly the 1999 one was written by Chief Justice Weisberger, even though again, it's an advisory opinion. It's not specifically signed by one of them, it's signed by multiples. But I would guess based on the writing style that was Chief Justice Weisberger, and that's where he said the commission has no rule. So respectfully, Commissioner, you may have an interpretation of what that Constitution means, but it's a judicial interpretation that governs. And the judicial interpretation from Justice Silverstein, again, a different case, I get that, was that if there's a clear constitutional process, neither the ethics code or ethics regulations can override it.
Can we ask you questions? I'm sorry, I don't want to, you have more. I don't know if we're jumping into that or I'll let you finish it up.
I'm sorry, did you have a question?
I do, yes. Is your proposition that since it is a constitutional process, no statutes or regulations can interfere with that process?
Correct. I will say,
So how do you account for judicial selection statutes that require a judge, a justice be around attorney, around resident, in good standing, around bar? That limits the governor's ability to appoint certain people. So why is that okay? And this statute, putting aside the and/or.
I was going to address that actually,
Great.
as you raised it. I think the answer to that question is that the Constitution specifically establishes the Judicial Nominating Commission, provides for a Judicial Nominating Commission. Now, interestingly, one would think, because the Judicial Nominating Commission was approved in 1994, one might suspect that the Judicial Nominating Commission was a product of the constitutional amendment. The statute was a product of the constitutional amendment. I think a closer look will tell you that the General Assembly enacted that before the constitutional provision came in. So the Constitution comes in, the constitutional provision is, as we should know, the way the Constitution's amended is it has to be approved by both houses of the General Assembly, then submitted to the voters, then voted on, and then certified as having passed. Well, in 2004, the election was in November, okay? The General Assembly had drafted and was in the process of proposing the constitutional amendment during the 1994 session, but enacted the Judicial Nominating Commission in that same 1994 session before the constitutional provision was adopted by the voters. I would take that to mean that the adoption of the constitutional provision was a sort of ratification of what the General Assembly had proposed, had already enacted. So there's an interplay between the statute and the constitutional provision that was adopted by the voters overwhelmingly. Now, some of the qualifications in there, I mean, if somebody wasn't an attorney, I think of being an attorney is one of the requirements.
Yes.
If somebody who wasn't an attorney, I mean, that's a hypothetical, that's not even a bar exam hypothetical. It's so outlandish. But if someone who wasn't an attorney applied for the position, they're never going to get interviewed even by the commission, but assume that they did apply and wanted to be interviewed. I suppose they could go to court and argue, well, it doesn't say that in the Constitution, so therefore the JNC can't consider it. I think there's a notion that creating the JNC, as the Constitution does, requires it to screen. And so the statute is an effort to give it some guidance on how to screen. Again, a statute enacted before the Constitution. Might that non-lawyer, if they file in, Superior or Supreme Court, arguing, hey, I have a right to be considered? Maybe they're right. I don't know. They're never going to get through the JNC, and they're never going to be, nominated by the, so it's kind of a silly hypothetical in that sense. So I mean, is it possible that the General Assembly could enact some revision to the JNC statute that was so inconsistent with the Constitution that a court might hold it unconstitutional? Sure. That's how lawyers make money, right? Is making those kinds of arguments. But I don't think there is an inconsistency, which, by the way, this commission doesn't have the authority to rule on anyway, because it doesn't have the authority to make constitutional determinations under Chief Justice Weisberger's presumably 1999 advisory opinion. But I don't think that the commission should be troubled by that aspect of it. It's not really the issue that's before you. The question is, as I stated, is, after the adoption of the 1994 amendments creating the Judicial Nominating Commission, or establishing the Judicial Nominating Commission, and after the 1999 advisory opinion, it's pretty clear that the Constitution governs over any statute. The other interesting thing is, take your hypothetical a little bit further. It's been pretty clear from the Supreme Court with regard to the Ethics Commission's authority. So, and even statutes enacted under the Code of Ethics, as part of the Code of Ethics, that, again, the Constitution governs. So, if there were such an inconsistency, you'd have to look to the Constitution and see whether that inconsistency fits. We've seen that in a number of situations with the Ethics Commission.
Justice Weisberger mentioned harmonization.
My memory is that the word harmonization appears in Chief Justice in the advisory from 1993. I may be mistaken about that, but that's my recollection. And again, 1993 has to be viewed in light of the fact that the governor had no appointment power at that time. So Governor Sondland's question, doesn't this interfere, or does this interfere with my power to appoint judges? That was not a constitutional power. It was a statutory power. And so the court Chief Justice Fay, presumably, his opinion was pretty clear that, well, I mean, it was explicit in saying, we don't have to worry about constitutional authority of appointment for the governor because he doesn't have it.
That was all before the revolving door statute.
No, that was about the revolving door statute, the 1994 ethics. The 1993 and 1994 were both about the revolving door. I believe the 1993 one, well, I don't remember which specific office it was discussing. But I believe it was a request from the governor about whether the revolving door interfered with his appointment power. That's my recollection of it. I
Wasn't that
made,
just a predicate question though, to the providing the advisory opinion? It wasn't the holding, it was that, well, this could disqualify from us answering the question in the first place because you don't have that appointment power, but we're gonna answer your question anyways.
well, that, I mean, if you deal with the Supreme Court over the years on advisory opinions, virtually every one of them, maybe not every one, but virtually every one of them has a paragraph in there that says, well, this isn't really part of our advisory opinion power, but we're gonna answer it anyway. Because their advisory opinion power is very narrow. But they said because the governor doesn't have the reason it wasn't part of their advisory opinion power.
Right.
Was because the governor doesn't have a present duty of awaiting exercise. And the reason he doesn't have a present duty of awaiting exercise is because he doesn't have a constitutional duty of appointment. So you may call it a premise, pretty important premise. To what the court ultimately said. Again, it's advisory. So I think everything in it is worth, being weighed and considered. So unless there are any other questions,
Could we get back, with all due respect, sir, could we get back to the exact wording of 36-14-5 and 3, which I believe is part of your primary argument, that states nothing contained herein shall prohibit a state elected official from seeking or being elected for any other constitutional office. Now, your argument is the general offices are a constitutional office, the 5 general offices. Am I correct?
well, I think so.
I agree.
Yes.
And also within the Constitution as adopted by the people, the state Supreme Court is designated as having the plenary power of the judiciary as established by the will of the people in adopting this constitutional. So that it seems to me that the Supreme Court is a constitutional court, and your reference to the other lower courts that the General Assembly may choose to enact by statute, a statutory court.
Correct.
Okay?
Correct.
Now, when the wording says nothing contained herein, which is part of all of the enumerated prohibited activities,
Right.
do you maintain that that applies to all of the enumerated activities in the same section? As in the past, Commissioner Peterson has alleged that you look towards the whole, I think, if before.
Well, nothing is a pretty all-inclusive or all-exclusive word, I guess. It's a superlative, right? It's not like some contained herein, it's nothing contained herein, so it does relate back to the entire act.
It relates to the entire act. And is it? I'm having trouble following the line of questioning regarding the appointment to a Supreme Court, not necessarily by you, but by the interplay between you and the other commissioner. Is it my understanding that you're arguing that the Article 10, which established the Supreme Court and also established the JNC.
Correct.
Okay. Eradicated the applicability of the election provision in 36-14-5 and 3. Because now the Supreme Court justices have to go through the JNC.
Right.
And they're confirmed by the separate bodies.
Right.
So in that way, are you maintaining that the adoption of the JNC in Article 10 eradicates the applicability of the elected word within the contents of your position?
Well, if your question is, would I say that the provision no longer protects, say, a member of the General Assembly from running for Attorney General? It still protects that.
Oh, it does. No, I meant with regard to your position regarding seeking the Supreme
Right,
Court. I'm
right.
sorry if I was,
Right.
sorry.
Okay, I just wanted to be clear. No, I think, if I'm answering your question, I think it applies to seeking or being elected. And so if Mr. Shikarchi had decided he was going to run for, I don't know, lieutenant governor or anything, and was elected to, as Attorney General, he'd be protected by this statute.
Right.
Just as if he seeks a constitutional office. And I mean, I'd have to, I haven't committed the entire Constitution to memory. My thinking is the only constitutional offices that are appointed are, well, I guess the Ethics Commission, right? The JNC and the Supreme Court, constitutional office. So I think it applies to anyone seeking appointment to any constitutional office. And in this case, we just need to talk about the Supreme Court. And I think you're right, Commissioner. There shouldn't be any question the Supreme Court is, I mean, going back to 1843 and Taylor versus Place explains in 1850 something, explains how one of the purposes of the 1843 language in Article 10 was to separate the Supreme Court and to give all judicial power to it, whereas previously some judicial power had been exercised by the General Assembly. And that's what Taylor versus Place was about. So I think let's put it this way. I wouldn't get up in a Rhode Island court and argue that the Rhode Island Supreme Court is not a constitutional office. I would recommend to anyone that they do so. And I would be happy to oppose the argument of anyone who does so. But I do want to turn briefly to the appointment in 2020 of Supreme Court Justice Aaron Lynch Prada, because I think that is instructive in a proper understanding of what all these things mean and how they work together. As the commission, some commissioners were here, no doubt, but as the commission. Nobody's here?
Nobody was here.
Okay. At that time, there was an argument or a theory that because she was a sitting senator, Justice Prada could not seek position on the Supreme Court. She came here for an advisory opinion. The staff recommended that she could not seek, that she withdraw her application. The commission deliberated on that and voted not to adopt the advisory opinion. So we end up, I don't want to call it a draw because she moves on and becomes a justice on the Rhode Island Supreme Court. But we end up with the commission not accepting the recommendation of the staff. Similar, I think, to the argument that the prosecutor is making here. So Justice Lynch Prada proceeds with her application. The JNC did what it was authorized to do, recommended her. Governor Raimondo did what she was authorized to do, nominated her. Both houses of the General Assembly gave advice and consent. The governor appointed her, and she took her seat on the Rhode Island Supreme Court, where she has served candidly, I think with honor, no doubt with honor, and I think with distinction. And there has to be some merit to the process that followed after this commission declined to give an advisory opinion, telling her not to do that. There has to be some weight given to the fact that all of the other constitutional officers or all of the other constitutional entities who were given the authority under Article 10, Section 4 in the 1994 overwhelmingly approved judicial selection amendments, that all of them agreed that this sitting senator could be a Supreme Court justice, notwithstanding, the position taken by staff here, and no doubt, by some critics who have nothing to say, I would suggest, about what kind of justice she's been. Or how well she's done the job of being a Supreme Court justice. And so, I don't know whether I'm arguing that that's binding on the commission. I don't think that's the argument I'm making. But it ought to be persuasive, and certainly what other constitutional actors did after the commission declined to adopt that position has to be entitled to some weight, given their role in the constitutionally designated process for selection of Supreme Court justices. And if there's any doubt about who has a role in that process, I'm going to quote an article written by a professor at Roger Williams University Law School in 1996. This is after the 94 JNC amendment, before the 2004 separation of powers, but after the JNC amendment. And what this professor identified as the process: the nominating commission, the governor, and the members of the General Assembly share responsibility and authority for selecting judges. Pretty much sums it up. That Roger Williams law professor, let me just check to see what his name was. Oh, Michael Yelnowski, complainant in this case. I think that sums it up. I think all of these cases weave together to provide that this is a constitutionally approved process.
There's no reference to the revolving door statute, it's a state, correct?
I don't recall. I read
Well, that's the reason why we're here.
it's an article. As many law review articles it's probably about twice as long as it needs to be. But it more was addressing things that had happened right after the JNC came in, where, as many of us will recall, there were a couple nominations that were made by Governor Almond that either didn't get approved in the General Assembly. I think that was Carmen, and that were withdrawn. That was Pfeiffer. And so the question was, is the JNC entitled to, is the governor entitled to a new list? And the court holds that he is. But what Yelnowski's point was, we have this process, let it work. And so.
But you conveniently avoid the issue before us now. And
No, I think the issue before you now, with all due respect, is whether, as the courts have said, a constitutionally established process for filling an office overrides either a statute or a regulation on ethics.
no argument there.
Okay, well, if that's what Justice Silverstein said, and that's what the commission
I
should.
go back to what I originally asked you, that is, you distinguish between elected and appointed.
Well, they're
I
different.
think, well, again.
There's no question that they're different.
Well, there you go. So, the
But-
argument that Commissioner Severini, rightly points out that it's a constitutional court, no dispute over that. What he wanted you to answer the question, can you now, based upon your presentation, you now say that we have included, eliminated term elected, and you stick with appointed.
No, I don't think,
You can't answer that.
I don't think,
question
no, sir, I will answer it. We don't eliminate the
because- There you
term.
go.
Elected applies to those people who are running for elective office.
Okay.
Seeking applies to someone who is seeking constitutional office. And that's what the complaint alleges. The complaint alleges violation of the code of ethics by seeking seeking what amounts to a constitutional office. And on that allegation,
But the statute refers to this, and that makes it very clear, we're talking about elected, not seeking. And there's no election to the Supreme Court here.
Is it possible that, you mentioned that you're going to get to, the legal significance of difference between the word or and. Is that appropriate at this time or later?
well, I know, it's certainly discussed in our memo. And the case law says, they mean different things. Or means disjunctive, and means means conjunctive. And the General Assembly knows the difference. And when they enact something, they are presumed to understand that there is a difference between or and or means this or that. So nothing in herein prohibits an elected official from seeking a constitutional office or being elected to a constitutional office.
Is my understanding erroneous that the word or implies meeting a single condition
Right,
and that the word and is interpreted to mean that you gotta meet multiple conditions?
correct, correct. And there are cases addressing it and, you know, who's qualified to do a certain thing, and they list qualifications are A or B or C. And then other situations where they list A and B and C, and they're different. And
Is there
so,
any insight into why N1 says seek or accept versus seek or elect? That's frankly where I'm hung up. I'm very hung up on that. That's the crux of this for me. Why is it seek or accept versus seek or elect?
I can't answer that question specifically, but I will say, you know, you have to read the exemption statute on its terms for what it is.
Right.
And you have to read it in light of what the Supreme Court and Justice Silverstein have said about the relationship between ethics, statutes, and regulations and the Constitution, and the Constitution governs. And the constitutional process is laid out in the the 1994 amendment and in Article 10(4). And
That's compensation again, isn't it?
well, harmonization in the sense that, you know, the Constitution is the melody, and if there's something, if there's a counter melody, you can't follow the counter melody. I'm sorry?
You have to have music,
If there's a counter melody,
someone has to play it.
if there's a counter melody, the melody governs, and that's the Constitution. That, I don't think, there shouldn't be any question about that.
Well, there was no question, but again, my concern, and I'm hung up on this as Commissioner Peters. So elected and appointed.
Yeah, I think if you follow Judge Silverstein's reasoning in them. And frankly, the position that the commission took in the Costantino advisory opinion, which again, I understand is not binding, but it ought to be persuasive. If you follow those, then you would recognize that you don't really ever have to get to the exemption. Because the Constitution has a specific process. And a specific constitutionally established process for appointment or selection is paramount and governs.
So would you say that, to me, selection and appointment is a different process than disqualifying or perhaps saying you're violating the code of ethics? We could say that this is a violation and the JNC could proceed. We're not telling the JNC who they can and can't nominate. We're not telling the governor who to appoint.
Okay.
We don't have that authority. I completely agree with you.
Candidly, I wouldn't make that argument in court. Because the fact of the matter is, you're telling the person that they're subject to ethics prosecution for doing what, we're not telling you can't appoint him, but we say he's violating the code of ethics.
Yeah.
I mean, I don't think a court would countenance that.
One concern I'd like to express is, I think some of the commissioners have questions regarding the alleged ambiguity of 5N3. When you remember, though, that it was in the code of ethics that each violation can, if found to exist, can be fined up to $25,000. That it's a rule of construction that, assuming without admitting that an ambiguity exists, a penal penalty requires, in that instance, that the ambiguity run to the favor of the person subject to the penalty. assuming that questions are being raised as to the ambiguity existing within the statute with the difference between the word elected and what the statute actually says.
May I just have a moment?
Certainly.
Okay, unless there are any questions, at this point, I will rest.
FC.
Morning, yes.
Couple issues. First, I might comment on a couple comments I heard, and then I'll do my roadmap. What to talk about. I wasn't expecting to hear about a 30-year-old law review article, particularly because I was the executive editor who edited that one 30 years ago. So my memory is that it did talk about the JNC a lot and very well, but not a lot about revolving. So today is a pretty monumental day, really, maybe more so than we thought about as it was leading up to today. And it's an important and significant day because, as far as I can tell, today will be the first time ever that a judicial or quasi-judicial tribunal is going to answer the question, can a sitting legislator move directly to the Supreme Court? It's never been answered. Not by the Ethics Commission, not by the Superior Court, not by the Supreme Court. And that's since the revolving door laws were enacted. Of course, as you know, the revolving door laws were addressed by many courts and by the Ethics Commission over the last 30 plus years. But it never had to answer that question. It never came up once. Not in the 92 advisory opinion, the 93 advisory opinion, 99, Inman, Costantino. And the commission has never answered that question. But today you're going to answer that question. It's surprising that the question's being answered by the Ethics Commission and not courts. And maybe it will be answered by the courts, in addition to by the Ethics Commission, depending upon what happens. But I think it's, to the extent that you haven't considered how momentous today's decision is, just want to remind you of that. It's also significant because, as I think what I heard from Respondents' Counsel, you think that you're answering the question, can a sitting legislator or the Speaker of the House move directly to the Supreme Court? And that is what you're answering today. But it sounds to me like the next question, which will be right on the heels of this, depending upon how you answer, is, well, what's stopping a legislator from moving to the Superior Court? We just heard that the Superior Court might be a constitutional office also, which is. But there are other arguments that are made in the briefs. If you accept the argument, which I'll get to when I discuss the constitutional portions, if you accept the argument that the Ethics Commission through the Code of Ethics can't stop the JNC process, the constitutional process of the Judicial Selection Clause, take a look at the clause. It's in the briefs. That clause is not limited to how Supreme Court justices get appointed. It also references the Superior Court and the Family Court, or the Workers' Compensation Court. So if the argument is that it's the JNC clause that is requiring the result that the respondent seeks today, then that's the next logical argument. So today we talk about whether someone can go to the Supreme Court tomorrow. The next question will be, well, can I go to the Workers' Compensation Court, Family Court, or the Superior?
Jason, you don't see any difference between the Supreme Court being founded in the Constitution and the trial courts being statutory courts?
Of
You don't
course
see
I
any-
do, of course I do. Yes,
Well, then I don't understand your argument.
well, take a look at the JNC clause. The JNC clause names out all of these courts. And it says for the Supreme Court, the JNC sends a list to the governor and then gets advice and consent from the Senate and the House. For these other courts, the JNC sends a list to the governor makes his selection, and it goes to the Senate only for confirmation. So what's the difference? They're two almost identical processes. The only difference in those two processes is that for the Supreme Court, it goes to the Senate. That's not a very big difference. And so if the argument, which is the argument he's making, if the argument is that the JNC clause trumps all the revolving door laws, period, because it's a constitutionally authorized process. Just telling you, that's the next argument. If what's good for the Supreme Court is going to be good for the Superior Court, Family Court, Workers' Compensation Court, and Administrative Adjudication Court, I think is named in the JNC clause. Yes, does that refer to the traffic tribunal now? I'm not sure if they're ready. So I just want to make those 2 points before I start the body of my presentation. If it pleases the commission, I would like to go in the reverse order the respondents council did. I would like to start with the statutory discussion and finish with the constitutional discussion. My understanding is that the argument on the statutory side, and so for this discussion, let us assume that everything is constitutional, right? One of the arguments that he's making is, before we get to the constitutional arguments, 5N3 has an exception that applies here. And because 5N3's exception applies, he should be allowed to do it under all 3 revolving door regulations. Okay, right, so that's the first argument. So let's just go through the revolving door laws, and I think that we're in agreement here. If you look at the 1991 adoption of 1.5.1, what does that prohibit? It prohibits a state elected official from accepting an appointment that requires the approval of their body while a member and for 1 year thereafter. Okay, that applies, right? I mean, if we're not talking about the Constitution, so 1.5.1 applies to prohibit him from getting appointed, would prohibit him from becoming a Supreme Court justice. Just on its face, if the only thing we were looking at is 1.5.1, it's prohibited. I haven't seen any arguments that's not true. Now, 1.5.2, which is the second revolving door regulation, again, adopted by the Ethics Commission in 1992. 1991. No member of the General Assembly may accept state employment as defined in the code while serving and for 1 year thereafter. It was not held at the time of the election. No exceptions. That's it. The respondent is a member of the General Assembly. He's seeking state employment as that term is defined in the Code of Ethics, as my brief points out. Judgeship is unclassified state service. He's seeking it the same day he resigned his speakership and still maintained his membership in the General Assembly. So if we were only looking at this regulation, not looking at the other two, it's a violation. On its face, as it's written, with no arguments about whether it's appointed or elected or exceptions, it's a violation. So the two regulations are very clear violations of the revolving door. And if you look at the 93 advisory opinion, there's about a page in my brief where I pull quotes from the 93 advisory opinion. The court in 93 clearly understood that those two provisions, those very two provisions, prohibited appointments to the judiciary. I mean, it's right on point. That's what we're talking about, appointments to the judiciary. So now let's look at the third section, which is the statute, the General Assembly statute that came a year after. The prohibition section in subsection A almost exactly mirrors 1.5.2. The only difference is it broadens its application to any state elected official. So now it's not just members of the General Assembly, but the 5 general officers are also included in this prohibition. Other than that, it's nearly identical to 1.5.2. But the Assembly decided to add a few exceptions. The one was for appointments. I refer to it as the appointments exception. It refers to it shall not be a violation to seek or accept appointment to like a department director position, right? And as in the Costantino advisory opinion, even without that exception, that may well have violated the appointments clause, right? If we didn't have that exception. So that exception tracks the appointments clause of the Constitution. And I'll get back to the or business. Well, maybe I should get to it now. Seek or accept appointment. I have never argued that or means and. Never. I didn't do great in English in high school, but I got a lot better at it as I continued my education. And I understand what disjunctive means. I understand the difference between and or. I'm not arguing that or should mean and here. What I'm arguing is, what is the meaning of the two things on either side of or? So look at that first exception in N1(2), seek or accept appointment. Well, what does the seek? What word is missing? What word can we add and still make that make sense? The word is appointment. We can seek appointment in brackets or accept appointment. We only said appointment once because, the drafters were maybe a little lazy. Maybe we didn't know that this was going to turn out to hinge on this section. So seek, the invisible word appointment, or, yes, it's or, accept appointment. The same thing in subsection A, the main prohibition. What's the prohibition? It's seeking or accepting employment. We don't say seek employment or accept employment. It's understood that we're talking about seeking or accepting the same thing, which is employment. So for the 5N3 exception, this is the elections exception. You're allowed to seek or be elected to public office. And to make N3 consistent with the way that we've interpreted those other two parts of it, the exact same statute, we need to add election after seek. So you may seek brackets election, just like you could seek brackets appointment. You may seek election or the disjunctive or be elected to. And if you read that exception that way, it makes perfect sense. And furthermore, there is no other way that it could have been intended. 100%, that has to be the way that the drafters intended it to be read, because, as Respondents' Counsel pointed out, at that time, every single constitutional officer was elected. So what else could they have meant? Back then, you couldn't seek appointment to a constitutional office. You could only get elected to a constitutional office. You could only get elected to the Supreme Court. So seek or become elected to, at the time that was enacted, could only have referred to elective office. And this idea that, and the Constitution changed eventually, but that doesn't change the original intent of what it was to apply to. So we know that as drafted, the elections exception was intended to only apply to elections. So for these reasons, the exception just doesn't apply. And if the exception doesn't apply, then it's the exact same prohibition as regulation 1.5.2. And the respondent is prohibited by the statute by all three regulations. Clearly. So again, we're setting aside the constitutional arguments for the moment, but I will address them. Now.
Could I just?
Yes.
please-
Yes.
How do you reconcile your argument with the cited case law that states that when you use the word or, a single event triggers the exclusion versus the word and conveying that you've got to trigger multiple events? I just don't, I'm having difficulty reconciling your argument with the pronouncements of the Supreme Court in case law.
I'm happy to answer.
Yeah.
If you want, sure. So I don't see the discrepancy. For the prohibition, the reason he's prohibited is because he's only doing one of those two things right now. He's seeking. He's seeking state employment. So that's a violation. Later, if he accepts it, that will also be a violation. So with the exception at 5N3, it only applies if he's seeking, if he's either one of the two things, not both. He doesn't have to do both for the exception to apply. If he was doing one of those things, it would apply. I agree. The first thing that would be an exception would be seeking election to a constitutional office. He's not. The second thing that would invoke the exception is being elected to a constitutional office. And that's not going to happen either. So none of those is going to happen.
But everything after the word or is a separate event. As I understand your argument, you're merging them, and that's precluded since it's a disjunctive, according to the case law.
Well, I disagree, and I want to say that that's exactly what we do in 5N2 when we say seeking or being appointed to, and in 5N1 or 5NA, which is the main prohibition, which is seeking or accepting of employment. So we read in that word in both cases. We do it in 5A, we do it, or 5NA, we do it in 5N1, 5N2, and 5N3.
Let me just say this, your argument reminds me a little bit of Garth Brooks's song, Thank God for Unanswered Prayers, because when I looked at 36-14-5, the General Assembly, which has concurrent jurisdiction as a constitutional entity with the Ethics Commission. In 36-14-5 is the prohibited activities, uses the word or more than 100 times. Uses the word and approximately 10. Obviously, they had a definite meaning with the word or, where in my mind, you're blending the two in an offspring that I don't understand as far as rules of construction go.
But that's what the Supreme Court said, harmonization.
Can we discuss harmonization a bit?
I have a question first.
I have a question, Jason. Well, all the commissioners are new. 6 years ago, you and I were here along with Kathy DeRezzo. Many of the positions taken in the advisory opinion matter for Erin Lynch product are the same as being made today. And like you and I have a gentlemanly disagreement as to the meaning of the statute or the exemption in N3. But let me ask you this, because the argument, well, back in 2020, my view was that the exemption did apply And the word "or" was a big part of that. It's been 6 years have passed. To my knowledge, and, you know, the commission vote at the time was somewhat controversial. It was criticized. But in the intervening 6 years, is it fair to say the statute has not been amended at all?
So I will answer, obviously I'll answer all the questions but I want to preface this by saying. Ricky Simone, with all due respect and friends, and we do have a gentlemanly disagreement. I find your questioning in lieu of the commissioners to be a little out of the ordinary, right? In this situation. Not that being said, I will be happy to continue to answer questions if it's the will of the commission and of the chair.
Let me just say, was there any amendment to the statute? Or has there been any effort to establish a rule of regulation of the commission to try to clarify this? Or was the non-activity an acceptance of the Honorable Lynch Prada being there in the Supreme Court?
There have been no amendments to either the statute or the
Rules of
regulations during that time.
Will the issue before us now? That's the reading.
Yeah, I would, Jason, if you would mind, I would, if you're ready for it, like to hear how you address the constitutional argument.
Thank you. I would be happy to. And
Great.
if at a different time, if the commission would like to hear my views on if you find that exception applies, how the proper way to harmonize the statute with the regulation, I'd be happy to address that, but I would, at your request, be happy to move on to the constitutional arguments. Great. So the arguments, as I understand them, primary constitutional argument is that the judicial selection clause, which is the clause that was adopted in 1994 to create the Judicial Nominating Commission, that it sets forth I wrote this, a clear constitutional process, that no statute, the Ethics Commission's revolving door laws can't interfere with, and probably what's impermissibly interfere with, right? Substantially interfere with, and to do so would violate the supremacy clause, I would guess. So, and to make those arguments, the respondent is relying on primarily the Inman decision, also the 1999 advisory opinion from the Rhode Island Supreme Court, and to a lesser extent, the Costantino advisory opinion issued in 2010 from the Rhode Island Ethics Commission. So I'd like to address those. In the brief, one of the statements that's made is that prosecution wants you to disregard the Inman. And I want to be very clear. I do not want you to, that's not true. I do not asking you to disregard the Inman opinion. It exists. At the time the Ethics Commission agreed with it, I think we still agree with it now. The Inman decision is a decision that exists, but that doesn't change the fact that it's an unpublished Superior Court decision. And so my object in just dropping a footnote in my brief to note that just be aware it's an unpublished Superior Court decision. This goes to the Supreme Court. They are not going to treat it as precedent. It apparently shouldn't even be cited in the briefs if we go there. And the one point on that I want to make, but it's a side issue and I don't want to get caught up in it, is that Rule 18L, the Rules of Appellate Procedure, very clearly apply to Superior Court decisions. And Respondents' Counsel knows this. In my brief, I cited two cases. I didn't cite one case. I didn't cite the Mendez case, and that was it, to say that the Supreme Court will not consider Superior Court decisions. I also cited to Josephson versus Allied Insurance, which was written by someone who I think respondents counsel would agree has sufficient appellate experience, Justice Goldberg. And she very clearly identified the pleadings at issue that she applied Rule 18L to as two unpublished Superior Court decisions, not one-page orders. So now that's a complete red herring and sidetrack. Let's set that aside and let's just talk about it. Okay. Inman, you know the facts of Inman, you know what it was, but it was very, very different. First, the first way it was different, Inman fit perfectly into the exception, the elections exception of 3614(5)(3). Inman was seeking election to a constitutional office, or he was becoming elected to. I guess the facts of the case don't tell us whether he lobbied for it. Maybe he did, maybe he didn't. We don't know. But we know he got elected. We know it was an elected office. And so that perfectly fit without having to worry about disjunctives or what this means or anything else. Everyone agreed it fits the exception of 5(3), getting elected by the Grand Committee. It also fits into what they described as, and this was an example of the Constitution granting the Grand Committee, very clear, practically just one sentence clear, unfettered authority of the Grand Committee to elect anybody they choose. If there's a vacancy, the Grand Committee can elect some person to fill this role, period. And under such a clear grant of authority, with no caveats, what Judge Silverstein said in Inman is, in that situation, constitutionally, there's no room for a legislative body to come in later and try and take some of that power away. So the revolving door laws, when applied here, is a bridge too far. This grant of parliamentary authorities, or in this case, elections authority to the Grand Committee, isn't to be tinkered with. So that's not the case here, right? So the argument is that the judicial selection clause is an analogy to what we were just talking about, this unfettered authority. But you've got the JNC clause in front of you. It sets the most basic framework for what will later be established by statute. There shall be a JNC. But the last sentence, but all the powers and duties of the JNC will be established by statute some other time. So there's nothing in the Constitution that says that, for instance, JNC members are not going to apply for a judgeship. But the statutes say that. I guess those are unconstitutional. I guess JNC members should start applying for judgeships and make their arguments. It says that if you don't pay your bar dues, the statute says if you don't pay your bar dues a month late and you're no longer in good standing with the Bar Association, you can't apply for a judgeship. But the Constitution doesn't say that. So that must be an unconstitutional part of the statute as well. So either the revolving door laws are unconstitutional for us and the JNC and everyone, or they're not. And I'll submit to you, they're not. And we know they're not because the court said in 1993, looking at our revolving door laws, they hesitated to even call them restrictions. The court says, I don't even know if this is a restriction because it's so de minimis. It's so temporary. It's a minimal 1 year cooling off period, and then go ahead and apply. That is not a substantial impingement of a clear constitutional process that grants unfettered discretion. It is simply consistent with all of the other restrictions that are imposed on the JNC and the governor. The JNC clause says that the governor gets an appointment, right? But it doesn't say how. It doesn't say that he only gets to pick from 3 people. Right? It's a list. It doesn't say how big that list could be. That list could be 1,000 names long. It could include every citizen of the state. But he might just get 3 of them. That's an impingement.
That's a substantial impairment of appointment power. To say there are 1.1 million people in this state, Governor, you only get 3 to pick from. By the way, they better have paid their bar dues. They can't be on the JNC. They have to be in good standing. Oh, and let's not forget about all the mandatory criteria that are not imposed by Constitution, but by statute. They have to have great education and experience. They should probably be published. They have to have the right temperament. These aren't things that the JNC is supposed to think about. These are required criteria of what makes a highly qualified candidate. So as to Inman, this is not Inman. And it's also not Constantine, which involved another clear grant of authority to the governor to be able to appoint his lieutenants. The governor's ability to appoint his chief of staff or a department head, or in this case, the Secretary of Human Services, a cabinet level position. To interfere with the governor's clear constitutional appointment power to pick the right person for that job is again a bridge too far. The 1999 advisory opinion that the Respondents' Council relies on to say that it, to use his words, trumps some things, trump other things. The 92 and the 93 advisory opinion. The 1999 advisory opinion wasn't even about revolving door laws. So it had nothing to do. To the extent it mentioned these revolving door laws, it did so approvingly. The 99 opinion approvingly cited the 92 and 93 opinion. What it found a problem with was a new regulation where the Ethics Commission was trying to fundamentally change the nature of Rhode Island government. Back in the day, Rhode Island was a place of parliamentary supremacy where the General Assembly could even adjudicate, as Respondents' Council mentioned, had judicial power, had every power that was not specifically taken away from them in the Constitution. Parliament, not the federal model, but when we hear, oh, it was 3 separate and equal branches, that was not Rhode Island. But the Ethics Commission, through one of its regulations, thought it could change Rhode Island's form of government to that model. And the Supreme Court said, hold on, that's getting ahead of your skis. Remember, we said this in 92 and 93. You did a good job with those revolving door laws, but this is, again, a bridge too far. So this constitutional argument that suddenly the Ethics Commission's regulations, which the Supreme Court has already dubbed de minimis, minimal, temporary, rational, related to a legitimate government interest. Staying specifically, well, the people who enacted these rules could have reasonably thought that it should apply to the people in positions of high power, that they not trade on that power to move themselves into other government positions. The court thought that was a good reason to adopt revolving door laws in 92 and 93. It's still a good reason. It's a good reason for us to enforce today. On the constitutional issue, the last thing I'll say about that, having to answer your questions, is the Respondents' Council has, I think, properly mentioned that it's really the duty of the courts to decide constitutional issues. And generally, if you look at administrative law, it's the duty of an administrative agency to enforce the laws that are on its books and to zealously guard its jurisdiction until it's taken away from them by the judiciary, if it ever is. So these constitutional arguments are interesting and I love to argue them. And I know they're, and I respect and value all of your opinions on these issues. And you certainly may rule on them if you wish today, whatever you choose to do. But he is correct that the judiciary is the proper place to rule a statute or our regulations, which are not only on par with statute, but stand above them, which is the 1992 advisory opinion in the field of ethics. So
Happy to answer any questions.
Jason, what's your position regarding the Supreme Court? Is it a constitutional office?
Yes,
And are the justices of the Supreme Court constitutional officials?
certainly.
And, but, 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 but it's your position that although now the Supreme Court justices and all judges have to go through the JNC. I was part of the first class in '94 that went through the JNC. It was interesting experience. And I'm sure for every attorney who goes through it, it's an interesting experience.
I believe that law review article we cited discussed your journey through the JNC process.
Okay. But if that be true, as to the Supreme Court is a constitutional office, and a justice is a constitutional official, then how do you reconcile the exact wording of 36-14-5 and 3? Nothing contained herein, which is all of the prohibitions. And the Supreme Court has said, I believe, that the General Assembly being a constitutional entity, the Commission being a constitutional entity, they share powers regarding ethics. We are, although a constitutional officials, are not exclusive holders of that sacred obligation. When I read the exclusion, if the Ethics Commission can establish exemptions, as it's done like on matters that you've cited in your brief, then why can't the General Assembly establish exemptions to the prohibitions if they so choose?
Be happy to answer that.
Okay.
Be happy to answer that. So let's assume that the 5N3 exception applies for
Okay,
the sake of your argument.
yeah,
So however you want to read it, let's say that it's applicable. So we have a situation where the statute would allow it, but the two regulations wouldn't, and unless we do some harmonization of some kind. That exact scenario was addressed by the Rhode Island Supreme Court in their advisory opinion,
what year?
the 1992 advisory opinion.
But-
I cited in my brief.
I know, but the JNC process came in '94. Don't you have to harmonize it to the existing process regarding the Supreme Court?
Well, I mean, let's stick, if we may, to at least your first question, which is what do you do if the statute allows it and the regulations don't? The Supreme Court said two things. Said, number one, there may come a day where someone is in violation of the regulations, but not of the statute because of those exceptions. And the court told us in 1992 that if there's an irreconcilable conflict between a statute enacted by the General Assembly and a regulation enacted by the Ethics Commission, the Ethics Commission's regulation wins. That's the very clear holding of the 1992 advisory opinion. In '93, they recognized that you could be in violation of the revolving door regulations without violating the statute because of those exceptions. And but let's say, well, we should try to harmonize them. And the rules of statutory construction say it's a last resort to say don't apply one and just apply the other. So let's try to harmonize. The respondent's version of harmonization is to enforce the statute and its exception and take the Ethics Commission's superior regulations, rip them up and throw them in the fireplace and not look at them at all. and only applying the exception. That's not harmonization. It's not harmonization to completely disregard two of the three and to only impose the exception. Harmonization is to give impact to all of them, and there's a way to do that. There's a way to do that. The way to do it is to say that they all three prohibit the exact same conduct, and the exception in 5N3 can reasonably be interpreted to apply only to elective office. And if you do that, if you harmonize it that way, then all three provisions are in effect. That complies with the Inman decision. It's in perfect harmony with the Inman decision. It is in perfect harmony with the Costantino advisory opinion. And it is in perfect harmony with the 1999 advisory opinion of the Supreme Court. And you're protecting and honoring the important achievements of the Ethics Commission in 1991 in adopting these laws in the first place, and then fighting all the way to the Supreme Court 2 years in a row to keep them in place.
I have I guess a thread that maybe you can help with, Jason. Do we see any, do we see an issue with our definition of office? And maybe Commissioner Santorini, you can help me with this. In the cited offices of elected officials, when we pull that out of the Constitution, that's a single human. It's one person that's elected to that particular office, and then in, you know, through the statutes, they are and create their own agency to execute what their role is. The Supreme Court, it's the reasonable person here, non-attorney, that strikes me as in addition to an office, right, that is a function. And I'm wondering if there is, I'm not trying to be cute with words, but the Supreme Court is not necessarily a single human that is elected to a particular role, but a series of people that, you know, through a process are designed to run at the highest level our judiciary from a functional perspective. Does that matter at all, how those offices are interpreted? Because I use the term, Commissioner Santorini, officer, you know, as opposed to official, as an example, just in terms of putting it together. So I'm curious if you have any feedback about function versus office, and whether it does matter if the function of the Supreme Court is a multitude of, you know, human being professionals, and that the other offices are singular in nature. Does that matter?
I don't know that the function part matters. I'm not, it might, but I don't know. I do, though, I do agree with you here that while I'm willing to concede here that a Supreme Court justice is a constitutional officer, and as counsel said, you know, I certainly wouldn't go up to the court and argue that they're not, right? And that's not going to happen. Nevertheless, Supreme Court justices are not what we traditionally are thinking of when we refer to constitutional law. You know, the Constitution itself refers to the general officers, and when it does, it's talking about 5 people. The governor, lieutenant governor, treasurer, secretary of state, and attorney general. And in general parlance, when we talk about the general officers, you know, that's who we're talking about. So the idea that you as an ethics commissioner are a constitutional officer, you know, today may be the first time that someone has ever uttered those words aloud, right? By the way, does that mean that our next commissioner to replace Rabideau will be Representative whoever? That's a constitutional officer position also. I don't ever want to think about that. You know, I'm not going to think through that one down to its conclusion. So I don't know if that answers your question. Probably not.
If I might, it seems to me that the Constitution establishes general offices, the 5. In each one of them, the Secretary of State, the Governor, the Lieutenant Governor, the Attorney General, and the Treasurer are state officials. I think I agree with Jason on that point.
Are other questions? I have to say, it's 11 o'clock. We've been sitting for 2 hours. I think it's probably, if we could take a quick restroom break, get a drink of water and come back, and let's just say 5 minutes.
Thank you.
Just so you know, this is still recording.
Oh, yeah.
Yeah, microphones are on. I will pause the recording until we reconvene. But the media's microphones will still be on.
The media's microphones were on.
I can ask them to shut them off between the meeting, but